So Quincy, Daniel, and Elisa, on this one, you guys might as well come up. Hello, everybody. Welcome. I'll go ahead and call this meeting to order. Welcome, everybody. Today is April 4th, Friday. We're on the record from 11:50 to 12:50 to discuss work session regarding AO 2025-38 and AO 2025-40, amending Anchorage Municipal Code Title 21 to update the appeals process and create two new rezoning procedures. We'll start with introductions.
George Martinez.
Thank you. Mark Littlefield.
Karen Bronga. Anna Brawley.
Christopher Constant.
Exalta.
On the phone, Mr. Myers.
Yes, thank you, Chair.
Thank you. Anyone else on the phone? Not seeing anyone. And with the planning department and Department of Law, we'll go to introductions. The mayor's office.
Melissa Babb, Planning Department.
Quincy Arms, Legal Department.
Graham Downey, Mayor's Office.
Daniel McKenna-Fusser, Long Range Planning.
All right. We do have a couple people in the audience as well. So we have two ordinances before us, one regarding the appeals process and one regarding rezone procedures. I don't have an opinion on which one goes first. So who would like to start? Which one?
Appeals go fast. Don't you think?
Okay, the member has requested in the mayor's staff that we go through the appeals process ordinance first, and so we'll go ahead, come on up. Mr. Spinelli. So I hand it off to you, Quincy. Graham?
I think I'll start us off. Thanks, Chair. So the gist of this ordinance, which very thankful to Members Altel for the partnership in developing, we heard numerous reports of the appeals process sort of getting used to just simply stop housing development. And in addition, the Alaska Supreme Court recently had a ruling where they decided that the state rules for standing require interest or injury, meaning in order to bring an appeal in state court, you have to be harmed by a decision in some way. So we're looking at aligning the municipality's administrative process for appeals to align with those state court rules. The idea being, if you are harmed by a decision of the platting or zoning boards, then you can still bring that appeals. But if you just happen to be a person who testified at the hearing, you're not going to be able to bring an appeal unless you're in some way harmed by that decision. So that's sort of the gist of the appeals reform. In addition, we did slightly, or I think maybe increase the fees. As always, when we increase fees, they need to be proportional to costs. In this case, we understand in some cases, appeals can cost the municipality as much as $25,000 in staff resources. So we think the fees considerably below that. But again, we're mostly looking to the change in the standing rules in order to ensure that people still have the right to appeal cases when they're harmed, but that it can't be abused just to stop housing. I'm happy Quincy's available to speak to sort of more specific legal questions, but happy to take thoughts or questions on the appeals piece.
Sure. Go ahead, Ms. Bryant, then Ms.
Yeah, thank you. Yeah, actually, I was kind of surprised. I appreciate this being brought forward. I understand the issue. I was surprised even to know that you didn't need some kind of standing. That seems like an odd, anyway, we don't need to get into kind of why the code is the way now, but it seems like that would be in most other situations why you can bring the suit. So I guess my question is, what can you characterize a little bit, and maybe this is a question for Quincy, kind of what would a harm look like, right? Is it just, because I imagine that there's a spectrum from I don't like this all the way to like the drainage is going to ruin my house foundation or something like that, right? There's a spectrum, but I'm wondering like what are some examples of harms, I guess, or potential harms?
This is Quincy through the chair. There haven't been a ton of examples in case law. The bigger example, the bigger category of cases are places where there isn't harm shown. So it's someone who just doesn't want to see this in their neighborhood, or someone who claims they're just acting for the better public interest and they don't like the way it's being legislated or something like that. The case law that I have read, it says specially and adversely affected. They use words like a sufficient personal stake in the outcome of the controversy, and an interest which is adversely affected by the complaint of conduct. So I can send you a bunch of cases out of Homer. They have a especially litigious person there. His last name is Griswold, and he has 4 different cases in front of the Alaska Supreme Court. These guys know him. Anyways, he's usually loses on standing because he's just someone that doesn't like Homer's zoning code, essentially. The one time that he did win a case was it was either directly adjacent to his property or on the same street. I can't remember, but it was at least like really close by. So that's kind of what I'm picturing as someone that it's like, because of the way the property is being developed, they're going to create drainage problems on that person's property or something like that. And in the cases that planning is seen in the past few years they don't have that kind of nexus. Most of them. Right.
Yeah, and I think, thank you. And I think a follow-up is kind of, if you can characterize, because the other thing I've heard is that this process can take a long time. So maybe just understanding kind of more exactly how the appeals process interacts with development. Like, does it add a year, right? And I know it depends on the case, but just maybe some concrete examples of how this is causing issues.
If I could defer perhaps to Mr. Spinelli on that question.
So, yeah, speaking to appeals, and I recently ended a long appeal process where the start was through the municipal process and the Board of Adjustment.
Mhm.
And that process probably on average slows a project down by a year. It costs the project 1 year. And it's really kind of the cheapest part of the whole, the least expensive part of the entire appeals process, because what happened with me was multiple Supreme and Superior Court cases, and that process was very expensive. And some of the standing was, if you're putting my life at danger by putting more vehicles on this road. So those are some of the claims against myself and the municipality and the plating board and basically everybody else under the sun that was listed on some of these complaints. And so that process, in my case, I was approved through the municipality, and just even though I had these cases going against me in court outside of the municipal process, I chose to continue forward with my development, invest the money in building out my road and recording my plat with legal action pending that could potentially, burden my entire development. So I guess what we need to think about is that not every developer is going to take that risk on. And so anything that we can do on the front end, which is because normally they all start with this process here, anything that we can do to make it harder to bring what I would call, I don't know, I guess I want to use a word that's not too rude. Basically, to try and make sure any appeals that we have are warranted and reduce the amount of bad ones. And leave it at that.
Sure, Mr. Nuisance. Mrs. Allentown.
Oh, I didn't know I was in queue, but so this has been in the works for a while. Kevin Cross and I worked on this. We were contacted by the development community. It's not only its uncertainty, it's cost, and it's the same folks typically filing the same appeals again and again. And what doesn't stop, and what we heard from the development community, is your finance obligations. If you have financed your project, you're still paying your finance fees. You are only able to proceed if you're going to kind of be the developer at risk. You are going to take on all of the risk of proceeding with your development while these cases pend. And there really isn't tight timelines for how fast these cases have to be dealt with once they are filed. And so that's another issue, is like once you get into the Board of Adjustment process, you're in this process, and then the court system is its own process, and there is no like expeditious way to get through it. So the idea is here to maybe to be able to better screen what gets through. And for me, standing is always like, what is the definable personal interest you have? And we've always been, we previously been allowing them, and my understanding is kind of just a general, I'm watching out for the community, and now you have to really tie it back to your own interests. So I would really suggest that if you have any concerns about this, that you take some time between now and Tuesday to talk with various developers who've been subject to this process, because they all have very unique and interesting stories, and what the actual impact, not only in their developments, but the cost and delay.
All right, next in the queue, I have Mr. Rivera, who joined us about 5 minutes ago.
Thank you, Mr. Chair.
Oh, sorry, you were here before.
I was here before, yes, but that's fine. Okay, so a few things. First is, and I'll just list all my questions out. So page 2 of the ordinance, and the party of interest means part B talks about aggrieved. Does that aggrieved have some kind of meaning in law? And maybe you went through that earlier when you were talking through the case law. Second is, the memo talks about a substantial increase in the number and complexity of land use appeals in recent years. Could you just give me those numbers, please? I'd like to know what those numbers are. And then 2, the memo also talks about a recent court decision. Could you give me that court decision, please? Thank you.
Okay, person aggrieved is defined through case law, I would say. I can send you some cases. It's also the standard that we use that the state uses in order to be able to appeal a case to the Superior Court. So there's a lot of case law on that, and I think this makes it simpler for everyone by making them the same standard, which is what a lot of boroughs have done and a lot of other municipalities have done. So you're not guessing at what standard to apply. I don't have numbers, and I don't think planning has numbers at this time, but we're working on it.
We can,
Sorry,
sorry,
didn't mean to speak
through
for you.
through the chair. I think that that's something that we can probably dig up and send to the assembly if required, if requested.
There was one more question. Oh, it's called Winco, and I can send it to you. I can send it to all the members. I could give you a brief synopsis if you want it.
Yeah, I think brief synopsis here would be helpful.
Okay, it was actually an appeal to the zoning board. They use the same party of interest standard that we had before this ordinance. It was basically like 2 business competitors arguing about the planning department's approval of a use determination. Like, is this really appropriate for a geology warehouse? And it was like very transparent that it was about the business interest. And the court found, no, that's not enough. You can't just be mad that you lost their business. That's not what we mean by a person aggrieved. That's kind of in a nutshell.
Thanks. I have myself in the queue, and I zoomed in on that same line B there. I wonder if, I understand there's a person aggrieved, you have asserted as a standard in case law and Alaska history. It certainly reads, though, that any person, right? And so I wonder if that language is exactly precise how we want it, if our intent is to narrow the kind of category of all possible. And so I understand I have a layperson's read, but a lay read of that code section reads that any person aggrieved by a final decision. It doesn't feel like it is narrowing. It feels like it's broadening. And so I can understand that I am just not a lawyer, but Dean, I don't know, Quincy, Dean said he wanted to jump in there.
I do. Thank you, Mr. Chair. Yeah, I think that that's important to recognize that the term aggrieved is really a legal term of art. It's used in case law often, and as Mr. Arms described, really focuses on someone that has an actual or a very real injury as a result of the decision or so forth. And it's very different from what we're changing from, and what we're changing from in the bracketed and capital, I guess, language. I guess B relates very much to the phrase the owner of property within the notification area. So often it's any owner of property within 500 feet of this whole area. Is for like a plot, for example, but maybe people like 450 feet away with property, they don't have any harm. There's no traffic on their roadway, but they're within the notification area. So it is narrowing that a little bit. They may not be aggrieved at all. There's also anyone that presented oral testimony at a public hearing or written testimony. So, the public hearing is open to anybody from the other side of Anchorage, for development over here. And so the person aggrieved really does narrow that. And so the other side of town is not going to be, I think, in any rational analysis aggrieved by development, 10 miles away in terms of their property interests. So it does narrow it a bit, and I think that Ms. Arms was offering a little analysis of the case law.
Yeah, so, and I just guess that Felix and Mr. Rivera and I both have the same kind of question. And it definitely doesn't read that way to the layperson, but if it reads that way to the attorneys and they have to defend it, I'm fine with it. Okay. Next in the queue, I have Ms. Braga.
Thank you. So I was back to the potential harms. So you were kind of like, would most of these be the Planning and Zoning Commission would have looked at the traffic, change of traffic, amount of traffic, possible foundation because of water. I'm thinking of some neighborhoods in my area that if you developed on the other side of the road, it's on a high hill, and if you pave the driveway, it's going to all drain down. So those I would say is potential harm. And so those would be looked at carefully with P&Z. And these are people who you've already decided there really is something in measure, a French drain or something to take care of that. And they're still saying no. Am I correct in that?
Yes, I would say so. Do you want to speak to some of the cases you have seen, or just Daniel? I don't know. Oh, can Mr. Spinelli speak?
Most of the appeals that I've seen are, I guess to say, the examples that you just mentioned are typically things that are resolved through municipal plan review. The municipal plan review and the existing municipal code framework doesn't allow people to just go build roads that swamp the guy next to them. Like our existing drainage code goes very far in the other direction from that. So I think the developing within the municipality, like along the codes that we have in place, is very responsible. So most of the appeals that you see are frivolous appeals that have very little merit. I wouldn't want to go so far as to say that none of them have merit, because maybe someday there might be one. And the appeals process does allow for myself or other developers to appeal what a plating board might come up with. But I think most of what you're speaking to is solved through the municipal code. Like our plan review process is pretty good, and it takes care of, I think you can trust that most of that's taken care of through our process.
Yeah, I agree. But also to sort of directly answer your question, I think the answer is if for some reason we messed up and we made the wrong decision, or PZC went above, if the chair of PZC went above and beyond to give somebody an exemption for something he shouldn't have, then a person could bring an appeal under this new regime.
So the other thing that flipped in my mind, so neighborhood covenants, how do they interplay with this? Because I know on Otter Drive, there's a house that they couldn't build a garage with a peaked roof because the house was down street, and they got it blocked because of solar, and it had to have a flat roof. Does a neighborhood covenant outweigh PZZ, or they together, or how does that work?
Can't tell you the answer to that. It's a neighborhood covenant that's recorded into the deed, and that's ultimately in the plat is the guiding rule for that land. And so it was the agreement by all the parties at the time when the land was being developed, or the association in its process. And so those rules do bind. Like, you cannot put in a duplex, even though it's allowed under the zoning, in an R1 zone in an area that is within an HOA that has conditions that are entitled. And so those protections exist.
I appreciate that. I've always wondered how that worked. And then the last thing is, I'm thinking about a homeowner, could be myself, that if they go before the planning board and they're denied something they want to build on their property, does this in any way keep you, an individual developer that's trying to do something with their land, from appealing? Or would you still, have the ability to do that if you had good reason?
My sense is that would be a pretty direct economic harm. And if it was reversed, you'd be able to improve your property value. So my sense, and Quincy can correct me if I'm wrong, is that this would not impact your rights.
Yeah, they are the entitlement applicant, so they're number one allowed. They're letter A allowed, sorry.
Other questions? Ms. Brawley, then Mr. Gates.
Yeah, thanks. First, just to say on the record, I think we should be cautious about and not that you guys were doing this, but we should be cautious about characterizing traffic as a harm, or increased traffic, because I think it's just the nature of when you build something that somebody is going to drive to that didn't exist before, it will create more traffic. Having a kid who turns 16 and then you buy them a car, that creates more traffic, right? So I just want to be very careful, because that is an argument that's used that I think is not necessarily a valid argument when you're talking about urban development. So just not that you guys were saying that, but I just want to say that on the record. My question is, I was just thinking about getting back to kind of who can do this. Is this something that's only the right of a property owner? Or let's say hypothetically there's a tenant leasing a house, and then they're the ones living in the house, but the owner is out of state, or whatever situation where they don't have an investment in what's happening exactly. Is that could that person have standing, or does it have to be a homeowner? Because I know we talk so much about notifying the owners of properties. That's really the way the code is written, but it's not necessarily who's living there. So I'm interested in how that interplay works.
This is Quincy through the chair. I don't see that limit in there. I don't think it's limited to homeowners. It's just any person aggrieved.
Mr. Gates, Mr. Sultan,
Thank you. I wanted to add 2 points, but I would also say I think that the burden's really on the person appealing to show they're aggrieved in what way. But the points I wanted to make, one is an example, and I've mentioned at the Rules Committee a few times, a Board of Adjustment appeals that we have, and one that has been appealed by a neighboring property owner to a subdivision plat up in the Bear Valley area, I think. Yep. And the persons in the area, but whether they're aggrieved is pretty questionable to me, but that's not part of our current code. This person appealed to the Board of Adjustment. It was denied as untimely. They appealed to Superior Court, got remanded, and then they went ahead and had a hearing. It got appealed again to Superior Court and back. So that's 4 years, I think, this when development's been on hold because this person's appeals with some questionable standing. Then I think this really helps narrow the ability for someone to do that kind of delay to a development that's going to provide 40, I forget if it's 80 lots or something for housing. So I just wanted to add that example that I've touched on before. And then I wanted to add one other thing. I think there's a little piece lacking in this ordinance, and that's it's a text amendment to Title 21. And I think we've all heard that text amendments have a process in code where it goes to the planning department and the planning and zoning commission for review recommendation before it gets to the assembly. And if we're waiving that process, that waiver's not here. And I think if we wanted to waive the planning and zoning commission review process, we need to amend this ordinance to say so. And I think it's sort of on a short notice to do so before Tuesday night. So I would suggest that if we're waiving the planning and zoning review process, to amend this, but continue the public hearing and have the S version with that waiver in it
Ms.
for
Salato.
future meeting.
Dean, I responded to your email. Can we just prepare a floor amendment for a waiver for both and state that that's the intention now, or do you need an S?
It's already begun.
Okay, great. Taken care of.
Mr. Salt.
Thank you, Chair. I have three questions for you. So first one, and I can't remember the section, but it's around the 51% ownership of an affected area. So the parcel that I'm thinking of is 100th and I'm blanking on it, the outside curve of Minnesota. So I know there's property owners in there that are trying to get 51% and then they'll push for a rezone. So if I'm not one of the 51%, and I'm not in the hypothetical, I assume that person's rights would be protected as well. Yes.
We're talking about the appeals ordinance as opposed to the rezone ordinance.
Okay. We'll get that next time.
Really, well, but we're almost there. So I had an inquiry yesterday from a member of the development community who asked if they could participate as well. I checked in with the mayor's staff, who was at least in part the sponsor of this ordinance, and they said, yes, the more the merrier. So we'll invite you up, Connie, if you want to be heard briefly. You have to come to a mic if you want to talk. If you don't want to talk, that's fine. Okay, so written comments will be submitted. So any further discussion on this ordinance before we pivot to the next one? Okay, looks like you might be off the hook, Quincy. So we will now pivot to, oh, are you providing counsel on the next one too? Okay. The next one is AO 2025-40, which is an ordinance amending AMC Chapter 2103 to create two new zoning map amendment processes, including a rezone process initiated by a municipality, an abbreviated rezone process for rezones that do not require change to the comprehensive plan. And I'm told there's an S version. So who would like to present this?
I'll kick us off, but I'll pass it over to Mr. McKenna Foster to dig into the details. And we've also, we have Allison Lang from the Department of Law on the phone available for questions on this one, and Devin Kelly from Cook Inlet Housing Authority to speak to a specific example of the implementation of this change. To speak very broadly, the impetus for this change is, we've heard pretty frequently from the planning department that they need clarity about what happens when the municipality initiates a rezone. As you experienced as a body recently, there's a lot of confusion about what is an area-wide rezone. Does it have to go through the same rezone process as an individual property owner? And so with this ordinance, we're trying to sort of answer some of the questions about what it looks like when the mayor, the assembly, the administration, or the planning and zoning commission initiate a rezone. Trying to create a clear process that creates clear public expectations throughout that process, and gives guidance to you as members about sort of how we're going to go about doing rezones. Critically, for those municipally led rezones, it's only rezones that apply to multiple parcels. So this isn't going to allow us to go in and pick a specific winner or loser. It's not going to let us do that spot zoning. This is critical to a lot of the ideas that are in our plans, overlays, targeted area rezones. There are a number of places in our comprehensive plan that call for area-wide rezones. We can't implement those unless we have a clear process for the municipality to actually do so. So that's sort of the first problem we're trying to solve with this ordinance, clarity in terms of how the municipality initiates rezones. The second piece is for individual individual rezones that implement some aspect of the comprehensive plan. So I think Daniel will speak to more of what that looks like, but there are many places in the comprehensive plan and especially in the land use plan map that call for rezones. And then put the burden of that rezone on the individual property owner to follow through on. That process can be expensive, uncertain, take a long amount of time. Is that we haven't seen a lot of individual property owners decide to take on that burden and risk and cost of implementing the plans. So by streamlining the process just a little bit, we're still maintaining many critical steps of public involvement, including planning and zoning, including you all voting on this and having hearings on each rezone. But we're trying to streamline that process in order to encourage individuals to implement the plan for their specific parcels, and also to remove special limitations when it's appropriate, which this body has decided is a priority recently. So I'll pass it over to Daniel to speak to sort of some of the specifics of this ordinance, and then hopefully we'll also hear from Ms. Kelly on some of the impacts we hope to see if it passes.
Thank you. Again, Daniel McKenna Foster, Long Range Planning. I'll go through these very quickly. Just to start out, very basic, the difference between zoning and a land use plan. Zoning is what's allowed by the code. The land use plan or the future land use map is kind of the way things are supposed to look in the future. And the intent of this whole process is that over time, things get closer and closer to the future land use map. So zoning is supposed to implement that plan. So the system is such that over time, zoning is rezoning is normal and natural. Rezoning is, of course, changing the designation. And it's natural and normal in a city that over time it changes and you change those designations to be in line with the plan as it is adopted. Again, this is in the code. The purpose of Title 21 is to implement the plan. So here's just an example. On the left, that's zoning from the Anchorage borough. In the middle is a land use plan. And on the right is sort of a graph of what that would look like over time. So over time, rezonings are normal, changes are normal in a city, and it's always moving towards fulfilling the plan. In Anchorage, there haven't been a lot of changes though, because it's a pretty high barrier to rezone. On the left here, this is an image of Anchorage zoning when it was a borough in the 1970s, and MOA zoning today in the 2020s. And you'll see some of the zoning has been exactly the same for over 50 years. And a lot of R1 is actually unchanged. So on that map, you can see the sort of panhandle of Airport Heights and R1. It's been zoned that way for a very, very long time. This is currently the way the chapter works. We have a couple of different types of rezones, but some of these items are buried in some of the letter numbers. So what we did is we not only added some new tools, but we sort of reorganized it so somebody going through reading the code can see all 5 tools laid out. So these are the tools that exist now. You have rezonings to change the required change to the comprehensive plan, rezonings to create an overlay, and rezoning to create a planned community development district. And then we added 2 new ones, rezones that don't require change to the comprehensive plan. So that's already fulfilling the plan, so it's a little bit shorter. And then rezones initiated by the Assembly, the Administration, or Planning and Zoning, area-wide rezones, targeted area rezones, and overlays. So as Graham mentioned, there's a lot of policy support for this in 2040 and in 2020. 2020 actually has a policy, I think, talking about regulatory rezones that you would do without even going to the Assembly. That's not really allowed by law. So this has been a discussion for a really long time about how do we make it easier to either implement the plan or also use these tools. So most of the actions and strategies from 2040 you see here are about targeted rezones, overlays, housekeeping rezones, and that sort of thing. So quick overview of one of the new tools, the rezonings that don't require change to the comprehensive plan. It's a simpler process that takes less time because it's relying on the adoption of the comprehensive plan, basically saying, we did the comprehensive plan, the land use map. We agreed that that's the way things are going to look. And this is just following up on that, sort of fulfilling that plan. Probably going to be lower cost, but the fees ordinance the fee schedule is sort of separate from this. Always reviewed for consistency with the comprehensive plan, always reviewed by planning and zoning, always reviewed by the Assembly, always requires Assembly approval. That's all rezones because it's that sort of legislative action. A good example of this too is that you can remove a special limitation. So throughout the bowl, actually throughout the city, we have a lot of special limitations. Currently, to remove that it's as if you're rezoning to an entirely different zone. So this process would make it easier to do that. I believe Devin Kelly is here from Cook Inlet to provide a specific example of that, which is another indication of this is maybe we're moving in the right direction if we're hearing from people, oh, this would actually help us move development forward. Here's another example. Say you're in a zone and on the land use plan map says this area is going to be medium density residential in the future. You have a zone that doesn't quite meet those needs. Fulfilling that, it makes it a little bit easier to go through. So you have maybe RO, ROSL. The plan says this is going to be compact mixed residential medium in the future, and then you rezone to R3 or R4 or something like that. Just looking at the comparison of the processes. So the current process takes about 7 months. This new one to implement the comp plan might take about 4 months. Then the other tool, the new tool that's the Muni-led, simpler notification procedures, but will probably entail more department outreach because these are going to be big, like parks, protecting the parks rezone with park zoning, can't be used for a single property, fulfills guidance of the comprehensive plan, always reviewed for consistency with comp plan, always reviewed by planning and zoning, always reviewed by the assembly, and always requires assembly approval. And that procedure sort of looks like this. It's pretty similar. And here's a great example. 2 parks in Anchorage that currently one zoned R3 and one zoned R2M. And that wasn't intentional. It's probably just a legacy of what the zoning has been for a really long time. But this is the kind of thing where we currently do not have a tool to go through and rezone all these parks to park zoning. So right now they show up as residential zoning or something else. So that's something that's been on our sort of work plan since the 2040 plan was adopted, to just get that done. So this would then show up as PLI or Parks and Recreation, probably Parks and Recreation zoning. So it show up as green on the map. And that's not just for cosmetics, but also it has some implications for preserving that parkland. And then we ended up finding a number of other things. So we came up with an S version. I might leave it to the attorneys on that. And also Allison is on the phone. But with that, I will go for questions and also encourage talking to Devin from CHUC, because they have a project that would benefit. It seemed to align really well. So thank you.
Maybe go to Devin first. Go where?
Go to Devin first.
So I have a question on the slide deck before we get to questions. Can we go back a couple slides? One more, maybe. One more there. So I don't know that I want anyone to believe that one line there that says always reviewed by the Planning and Zoning Commission. I think that the assembly will and shall always maintain the right to waive any section of this code. And so I want that to be really clear, that that is communicated broadly. So it's not a surprise to anybody when someone else asserts that because this thing passed, now suddenly the assembly must be bound by a previous assembly's action. That I just want us to be really clear about. So I agree with everything there, but that one line. And so next, you want to wait for Devin, or do you want to ask your question first? Okay, Anna?
Yeah.
Okay, so Devin, go ahead. Thank you.
Thanks, everyone. Devin Kelly, Cook Inlet Housing Authority. And CHA has for several years recommended making policy changes that would allow the MOA to pursue targeted rezonings in line with the comprehensive plan. So we think this is a really sensible and good change. We also just generally really support the effort by the administration to acknowledge the public process that already happened leading up to the adoption of the land use plan and the comprehensive plan, and to remove hurdles to jumpstarting housing at a time when we really need it. So I was just going to share a quick story. So at the end of 2024, Cook Inlet acquired a 4.3 acre parcel that's in the DeBar Road, Northway Drive area for a future elder housing campus. The property is zoned R4. It's designated in the land use plan map for compact mixed residential medium housing. And our current concepts call for 70 to 80 units of housing. And this is, exactly in line with what the zoning would be. And so there's a special limitation from 1982, which is older than I am, that talks about, it's a little hard to tell exactly because the code doesn't exist anymore, what it's referring to, but we think that it calls for a major site plan review or a conditional use permit. So would need one of those things in order to build multifamily housing on a site that's zoned for multifamily housing, and that is called out in the comp plan for multifamily housing. And so these types of processes require CHA to design all phases of the project. So landscaping, civil, it costs hundreds of thousands of dollars. And it's at a point where we're looking out several years, having to do several phases, and the funding uncertainty is, if we had to make a change down the road, it would also be really expensive. We would just have to re-incur that cost. So I think that as you all know, major site plan review for larger housing projects was suspended through the design standard pause because of the disproportionate impact it has on larger housing projects. And the Assembly also has ended the use of special limitations last year. So these are just types of processes that we think really detract from future housing investment, and that's being recognized at this point. So maybe unsurprisingly, we intend to rezone the parcel in order to remove the special limitation so that we can pursue like any other R4 parcel. And making this change would cost $9,960 to process a rezone. And we'd also have to pay a consultant to handle the mailings and the public meeting aspect of what's currently in code. And just for comparison, last year we worked to fully rezone a parcel in Wasilla. We paid $500. We were able to take a couple hours to do the application ourselves. We went to the Planning and Zoning Commission and the Assembly in Wasilla to process that rezone. So we would really appreciate, as this ordinance would do, having the ability to process the rezone ourselves, go to the Planning and Zoning Commission, go to the Assembly. And I know that the fees are maybe part of a separate ordinance upcoming, but we would be happy to pay a more modest fee in order to process this simple change rather than paying $10,000. So thank you for, yeah.
Right, Randy.
All right, thank you, Chair. Now I'm on the right one. So a couple questions for you. So first one I'll dive into is section 21.03.020C2. Just want to better understand. So you're exempting, I guess, the community process, community meetings. But for some of these, like an area-wide rezoning or maybe an overlay, they seem pretty big. So I imagine there's some kind of process that's going to take that place. You're going to have to do some kind of outreach, I would assume. So if you could expand on that, that's number one. Number two was related to same section, 0.160B2. It was at 51%. Again, I'm thinking of that exterior curve on Minnesota and 100th, that if I'm in the minority of property owners in there, am I just along for the ride? And then the last one's around the director has some the ability to make determinations around whether it follows a comprehensive plan or not. I'd like to know, is there kind of a check? Some of it sounds pretty basic, but is there a checklist that they would follow? Or is there maybe even an appeal process in case someone feels that they were wrong? Thank you.
Through the chair, thank you for the questions. I think I'll start with the last question first, and forgive me if I have to ask you again for the others. Regarding the determination, we currently go through that process now for every rezone that comes in. We do that as a sort of a department-wide decision where I rely on the expertise of the current planning division and the long-range planning division to look at the comprehensive plan and determine whether or not the proposed rezone is in line with the comp plan. And then we go from there, whether or not they would need a comprehensive plan amendment or whether they can go through with just the general rezone process. So that's something that we do already. Regarding the 51%, that is also something that is already in code. For every rezone, a rezone only requires 51% of the permission of the property owners. So the rest of the property owners would be along for the ride. But they all do have the opportunity to protest that as part of the process as well. And that is retained for those rezones that are in line with the comprehensive plan. One of the new, the two new procedures would retain that protest. But for the muni-wide, the muni-initiated rezones, that the new process that we're proposing for that, that protest would not be part of that process. And then, I'm sorry, the other question.
Last one was community meetings.
The community meetings, those are relying on the process that the comprehensive plan has and the land use plan map have already been through. So for those to be approved by the assembly, we went through an entire year's long worth of process for community meetings and outreach and all of that community involvement. So that is covered by that process. And then, but there's still the community involvement in regards to the community members would have a chance to testify. They'd have the community councils would be notified. Muni-wide rezones, we would be doing a bunch of outreach just naturally. So hopefully that answers your questions.
Yes, it does. Thank you.
Ms. Polly.
Thanks. I have a few questions as well. The first one I'll preface with saying, I remember when I was not closely involved in the land use plan development in 2015, 2017, around that time. But I remember a presentation to our community council land use committee where a planner said essentially, Turnigan wouldn't be affected because the land use plan basically is only showing what was built there now, like basically saying that it's built to the current zoning capacity. So that makes me wonder, I mean, that's just one neighborhood, obviously. So I'm wondering how many, do you have a sense of kind of what proportion of the city or about how many properties, and not a number, but just kind of characterizing where the zoning does not match what the land use plan wants? Because what I'm hearing is some places, and even the places you mentioned, maybe the zoning hasn't changed, but the land use plan matches that. So I'm just wondering kind of how, I'm just trying to think of scale, like if the city pursued every single targeted rezone that it could at the same time, right? Like what percentage of the city does that affect? Or not even at the same time, but just what is that total?
Through the chair. Yeah, I think you're right. The 2040 plan, if you look at it, it does seem to in many ways reflect the existing conditions when often the plan is looking a little bit further forward. But so because of that, there are a lot of areas that the designation isn't really that different. And so I can't give you a percentage, but I don't think you would see areas that are traditionally maybe lower density. Most of them are not designated for higher density in the plan. And if that was going to change, that would of course be a much bigger discussion and you'd have to change the land use plan map. I would say most of what there are a few tiny areas, but most of what you'd see is probably on the fringe of other areas that were already centers, like around the UMed area, where it's saying this area is probably going to transition from retail RO maybe to R4 or R3 or something like that. So I would look around the edge, and the GIS has put together this great swipe map where you can look at the zoning and the comp plan designations at once. And looking at that, you can really see, because it really jumps out where the differences are. And there aren't that many differences, but there are just enough where if somebody's willing to do it and they say, hey, I could go up to R3 on R2M, like, why don't I do it? It kind of behooves us all to do that because they're implementing the plan for all of us. So I don't think it's a massive, I don't know what the percentage is, but check me, look at the plan, look at that swipe map, and you'll see that it's probably around the fringes, but not everywhere at once.
Thanks. And then my other question, and I'm glad you brought up the plan. I was just looking back at the land use plan, and then the 2020 plan, of course, says urban transition, right? So exactly what you just said. It says that over time we are looking at at least some places becoming more dense, or just more intensity of development. I'm wondering, because I was just looking back, so page 93 to 95 in the 2040 plan, for anybody who's interested, literally talks about targeted area rezones. It is a strategy. And I'm glad that we are finally pursuing that. And so thank you for doing that. But I'm wondering kind of, because I know there's been some kind of concern about the way this is written, is there an alternative to this? Because I'm wondering, as I read this, I look at the ordinance and it seems to be how you do this. So I'm just wondering, is there a second option? Or because the plan itself calls for reducing barriers, make it easier for an individual property owner to do it. So it seems like this is implementing what the plan calls for. And I'm just wondering if you guys thought of alternatives or if there is some other set of strategies that we could be using. Because again, it seems like this is a straightforward implementation ordinance, but I'm just wondering, because it seems to be giving some folks some heartburn. So I'm just wondering kind of what our other options would be.
Thank you. Through the chair, honestly, I cannot think of any other option that we would have to implement the plan other than maybe reducing barriers for individuals to rezone even more so than we're proposing here, because it's a pretty straightforward question in the plan. We need to do these things. We don't have that instrument in Title 21 currently for whatever reason to do those things. So we're just trying to fill that gap.
Yeah, if I could add, I think I don't think we want to say this ordinance couldn't get amended or changed by you all. I think we've made choices about what pieces of the process to continue in these ordinances and which parts to not include. So we've decided to not include the community meetings because, sort of looking at the community benefit in terms of notification, we still have planning and zoning, we still have the assembly, we still have lots of other process. So we decided community meetings, we think that's probably been approximated or been done through the comp plan planning process. You could make a different decision obviously as the legislative body. And also to Chair Constance's point earlier, you can rezone things. There's limits to that in terms of takings and constitutional law, but as the assembly, that's sort of one alternative. The other alternative is the status quo, that we continue to require thousands and thousands of dollars spent on tens of thousands of mailers every time we try to change zoning for more than one parcel. So there is, there's always that counterfactual of we could continue to have the inaction we're seeing today.
Thanks. And then one brief last question. You mentioned that this doesn't allow rezoning of a single property. Can you speak to kind of why that would not be the case?
Through the chair, this does allow rezoning of a single property for certain types of rezones, for the individual rezones, but not for the muni-led, the muni-initiated rezone. And that is specifically to help avoid spot zoning.
Braga?
I was at University Community Council the other night, and they were talking about two South Central Foundation properties that have SL that, and I guess I wasn't clear, and maybe I don't need to get it answered in this format, but they're developed already, and so I guess I'm not sure why are you encouraging them to change that zoning designation because they want the SL taken away, but it's already a developed property, so I'm not sure what that's about, and if this has anything to do with this.
Through the chair, I do not believe that their situation, what they are proposing to do, has anything to do with this. And I'd be happy to speak with you afterwards about this. So yeah, if you don't mind, we can catch up after the meeting.
So we have about 7 minutes left.
Thanks. So I'm gonna, on Tuesday night, ask the indulgence of the body. I have an amendment that would be contingent on looking at the tax abatement ordinance to allow rezones to allow presumptive upzones to meet the minimum density requirements to be able to take advantage of the tax abatement. I would like to include it in this ordinance, but the order of operations would have to be, we'd have to take up the tax abatement ordinance first. So just a heads up, the amendment will be coming. The idea there is let's maximize all the tools possible. If you are held back from being able to and otherwise would qualify for a tax abatement, but you just can't get that last 2 units in, is that we should be able to use this tool very similar, because otherwise we are standing literally in our own policy way. So if you want to respond to it, that's great. I just wanted to give a heads up because it will be an interesting procedural move.
Yeah, to sort of potentially to preview, we do, in addition, to the degree the rezone ordinance passes, we would be potentially pursuing a couple area-wide rezones as a follow-on. One would be parks, and the other would potentially be to implement the transit-supported development overlay. And we would use, for our plan currently, is for the transit-supported development overlay to have the same map as the tax incentive. So it could be another way of achieving a similar goal.
Okay, well, we'll need to talk more about the tax incentive one because I didn't realize that that was limited in a particular area. And what I want to do is if anyone owns an individual parcel, wants to be able to take advantage of the tax incentive, is to presumptively talk about getting them up to that density versus what the muni might own in contiguous parcels.
So sorry, I understand. Yes, you're correct. The tax incentive is area-wide for 15 years. There's the bonus area, and we're planning for the bonus area to align with the transit-supported development overlay.
Great, sounds very complimentary. Thanks.
Yes.
Anyone else? Right, over there. Okay, I think then we're pretty close to the end of the work session. Thank you, everybody, for all of your work on getting this item up and before us. If there's nothing else, then we'll go ahead and be adjourned until 1 o'clock.